Welcome to the Deep Dive, where we take that stack of information and really pull out what you need to know.
Glad to be here.
So today we're tackling something super important for California renters: lease renewals. What happens when your lease is up?
Yeah, it's a big one.
We've got some great info here, stuff about the Tenant Protection Act, legal perspectives. Our goal today, give you, the California tenant, a clear picture of your rights.
And it's interesting because, California has some specific rules. It's not like a landlord can always just say, okay, lease is up, time to go, especially if you've been there a while.
Exactly. That's what we want to unpack. Like, when can they refuse to renew? What reasons are actually legit under the law? And, what are your rights in that situation? We'll even touch on, like, what if the lease just runs out and you kind of stay put?
Right.
Think of this as your shortcut guide to California lease renewals. Less jargon, more clarity.
Let's dive in.
Okay. So first things first. Let's say your lease is ending in California. Can the landlord just decide not to renew it? Simple yes or no.
Well, generally, yes. When the initial lease term expires, they can choose not to renew. But, and this is a really big but for you if you've lived there over a year,
Okay.
California's Tenant Protection Act, AB 1482, puts pretty significant limits on that.
AB 1482. Heard of that?
Yeah, so after you've been a tenant for 12 months, this law kicks in and says they need just cause to end your tenancy. And that includes choosing not to renew your lease.
Just cause.
Okay, it's partly there to stop landlords using non-renewal as a sort of backdoor way around rent control limits.
Gotcha. So just cause. What does that actually mean for a renter whose lease is coming up?
So if you hit that 1-year mark, your landlord can't just arbitrarily decide not to renew. They need a specific, legally valid reason that's the just cause.
And these reasons fall into category.
Exactly. 2 main types. At-fault just cause, which is about something the tenant did, and no-fault just cause, where it's not really about the tenant's actions.
Okay, let's start with at fault. What kind of things would put a tenant at fault enough for a non-renewal?
These are probably what you'd expect. Things like consistently not paying rent or, seriously breaking a major rule in the lease agreement.
Like having a pet when it clearly says no pets.
Precisely. Or causing major damage, not just normal wear and tear, but real damage. Using the place for illegal stuff is another one.
Makes sense.
Also, refusing to let the landlord enter for necessary repairs, assuming they gave proper notice. Or refusing to sign a new lease that's basically the same as your old one.
Okay, those seem fairly straightforward. What about the no-fault reasons? When can they not renew, even if you've been a perfect tenant?
Right, so no fault is different. The big one is owner move-in. This is where the owner or their kid, parent, grandparent, you get the idea, close family, intends to actually live in your unit. But there are some really important rules here, especially with updates from April 1st, 2024.
Oh, recent changes. What are they?
Yeah, so the owner or relative has to move in within 90 days after you leave, and they have to live there, make it their primary residence for at least a full year.
Wow, okay. A whole year.
Yep. And the notice they give you, it has to name the person moving in, state the relationship to the owner, and explicitly say you can ask for proof of that relationship.
That's good protection.
It is. And they can't use this reason if they already have a similar vacant unit on the property. If they don't follow through, say they just rent it out again quickly at a higher price, they could be on the hook for offering it back to you at the old rent, maybe even paying your moving costs.
That's significant. What other no-fault reasons exist?
Another major one is a substantial remodel or demolition. And keywords there are substantial and remodel.
Not just new paint or carpets, then.
Exactly. We're talking major work that needs permits messing with structural stuff, plumbing, electrical, or maybe removing hazardous materials like asbestos.
Okay.
And the work has to be serious enough that you genuinely need to move out for at least 30 days straight for it to be done safely.
So a quick kitchen upgrade doesn't count?
Probably not, no. And again, as of April 2024, the notice needs details. Describe the work, include permit copies, and tell you that if the work doesn't happen, you might get first dibs on renting it again.
Good to know. Any others?
Yes. The landlord deciding to take the property off the rental market entirely, permanently.
Selling it, maybe? Or just not renting it anymore?
Could be either, yeah. Or if there's some kind of government order, from a court or the city, saying the unit has to be vacated.
Got it. Now, flipping that, what reasons are absolutely not okay for a landlord to use for for non-renewal in California?
Oh, this is critical. Discrimination is absolutely forbidden. They cannot refuse to renew based on your race, religion, gender, disability, family status, like having kids, or importantly, your source of income.
Source of income, so like using a Section 8 voucher.
Exactly, that's protected. Also, retaliation is illegal.
Retaliation, meaning?
Meaning they can't decide not to renew just because you exercised your rights. Like, if you complained about needed repairs or reported a health code violation or joined a tenants union.
Okay, so they can't punish you for standing up for your rights?
No way. And finally, they can't just lie about the reason. We sometimes see renovictions where they claim major renovations are needed, but it's really just an excuse to get you out so they can hike the rent way up for the next person without doing much work. That can definitely be challenged.
Really vital points. So, assuming the landlord does have a valid just cause, what's the process? Do they just tell you?
No. Proper written notice is essential.
Yeah.
Always written. How much notice depends.
Right.
If you're month to month, typically you need at least 60 days written notice.
60 days. Okay.
For a fixed term lease, like a 1-year lease, the notice period is usually spelled out in the lease. It might be 30, 60, even 90 days before the lease ends. You need to check your specific agreement.
And this is separate from notice about rent increases, right?
Totally separate. Rent increases need their own written notice, generally 30 days for a 10% or less increase, and 90 days if it's more than 10% within a year.
Okay. Now, what if the lease just ends? Your 1-year lease is up, you haven't gotten notice to leave, you pay next month's rent, and the landlord accepts it. What happens then?
That's a common scenario. In California, usually if you stay after your fixed-term lease ends and the landlord accepts rent, it automatically converts to a month-to-month tenancy.
Oh, okay. So you're not just like squatting.
No, not at all. You become a month-to-month tenant, usually under the same terms as your original lease, unless new terms are properly communicated and agreed upon.
Does that change things much, being month to month?
It offers flexibility, sure, but it also means the landlord can end the tenancy with that shorter notice period, like the 60 days we mentioned, assuming they have just cause if you've been there over a year. And rent increases might happen more often with the proper 30 or 90-day notice.
Got it. You mentioned relocation assistance earlier for no-fault non-renewals. Can you expand on that?
Yes, absolutely. Under the statewide Tenant Protection Act, if your tenancy is ended for a no-fault reason owner move-in, substantial remodel, withdrawal from market, you're generally entitled to relocation assistance. The state minimum is equal to 1 month's rent. They can either pay you that amount or waive your last month's rent.
1 month's rent, is that always the amount?
That's the state baseline. But, and this is really important, many California cities and counties have their own local ordinances.
Local rules again.
Yes. And these local rules can, and often do, require more relocation assistance, sometimes significantly more. So you absolutely need to check what applies in your specific city or county.
That sounds critical. So state law is the floor, but local law might offer more protection.
Exactly. Think of state law, AB 1482, as the minimum standard. Cities like Los Angeles, San Francisco, Oakland, Santa Monica, and many others have much stricter rent control and eviction rules, including higher relocation fees and tighter just cause definitions. You really have to know your local landscape.
Okay, this is super helpful. So if you're a renter in California and you get a non-renewal notice and something feels off, maybe you suspect discrimination or retaliation or the just cause reason seems flimsy, especially if you've been there over a year, what should you actually do?
First step, always document everything. Keep your lease, keep every notice, save all emails, texts, letters back and forth with the landlord.
Paper trail.
Crucial. Gather any evidence you have that supports your suspicion, maybe proof the remodel isn't happening or evidence of past complaints you made right before the notice. You could also file complaints with government agencies like the California Department of Fair Employment and Housing or HUD.
Okay.
But honestly, the most important thing is to get legal advice quickly. Landlord-tenant law is complicated, and those local variations matter immensely.
Where can tenants turn for that kind of help?
There are tenant rights groups and legal aid societies, also specialized law firms. For example, Martinez Law Center, that's martinezlawcenter.com, they specifically represent tenants facing eviction or unlawful detainer actions.
martinezlawcenter.com.
Yes, they focus only on the tenant side, which is important, and cover areas like Orange County, Riverside, San Diego, and Los Angeles. Getting advice from someone who knows the local courts and tenant law is invaluable.
And there can be real consequences for landlords who break these rules.
Oh, absolutely. If a landlord violates the Tenant Protection Act, they can face serious penalties. They might have to pay you damages, cover your attorney's fees, and sometimes even pay triple damages, depending on the violation. It's serious stuff.
Wow. Okay, so wrapping this up, it's clear that California tenants have quite a few protections when it comes to lease renewals. It's definitely not just about the end date on the lease.
Not at all. That just cause requirement after 12 months is huge. Plus the strict notice rules and the prohibitions on discrimination and retaliation. These are real safeguards for you.
It really shifts the dynamic compared to some other places.
It really does. And it brings up a key question for you listening right now. Do you actually know the specific tenant laws in your city or county?
That's a great point.
Because while the state law gives you a foundation, those local rules could add really significant extra layers of security. It's absolutely worth doing a little digging on your local city or county government website.
Absolutely. Knowledge really is power here. If you're facing a non-renewal in California and any of this sounds familiar or you just feel unsure about your situation, don't wait.
Please don't.
Reach out for legal help. Again, Martinez Law Center at martinezlawcenter.com is one resource focused specifically on tenant rights in Southern California. Thanks so much for diving deep with us today.
My pleasure. It's crucial information.
Call now 714-442-9741. Thank you.